Hello and welcome to In-Depth Analysis, Polity and Governance this week. A series of video lectures, we are going to cover each and every subject with respect to whatever has happened, appeared in the current affairs, and of course is relevant for UPSC Civil Services JS examination. But before I begin the discussion, I would want you to have a look at our website, Anantam IAS or iasanantam.com, where we are producing very rigorous, beautiful current affairs articles which are easy to understand, comprehend, and I don't think there is any other portal which is providing such a curated current affairs on a daily basis. Also, for the ease, what we are doing is that we are segregating the news articles that are relevant only for the prelims examination and not for the mains examination, and we are compiling them in the form of prelims nuggets. So if you go to every day, you will see a prelims nugget where you will only see the prelims relevant news articles of the day. So stay tuned on our website, and let's now begin today's discussion with a very important news article, or rather an editorial, the malleable code of conduct. The code of conduct which is easy to bend and change the shape and form of. This editorial has been written in context of the announcement of Mukhyamantri Mahila Rozgar Yojana in Bihar, where just before the announcement of Bihar elections, the BJP government, or rather the NDA government, transferred 10,000 rupees in the accounts of thousands of women voters in Bihar, uh, probably distorting the level playing field, or sort of providing an official bribe, for the lack of better term, to the 50% of the population, which constitutes around 50% of the voter list as well. And that brings us to a very pertinent, relevant discussion with respect to whether there is a level playing field in India in terms of electoral politics or not. And if it is not, how can the model code of conduct be held responsible? So in this context, oftentimes we hear a term, model code of conduct, an ideal way in which the stakeholders to an election should behave. Stakeholders include all the participants to contestants to elections. They include the voters. They also includes the government officials, and it also includes the political executive, which means the then ministers or the council of ministers, because they hold a lot of authority and they can misuse that authority. It has always been relevant from the point of view of specially mains examination, because if you go and look at the GS paper 2 syllabus, it clearly says representation of the People's Act as a part of your syllabus. Representation of the People's Act, there are two kinds of representation of the People's Act. One is RPA 1950, which deals with largely the pre-electoral procedure, the seats allocation, delimitation, electoral roll creation, and all of that. And then there is RPA 1951, which is more of a substantive law, which takes care of all what's happening from the day of the announcement of the elections until its counting and declaration of the final results. So it is like intervening 3 to 4 months of the period, 2 to 3 months of the period, which it takes care of. Now, first thing, that obviously somewhere we have to begin, and the right kind of beginning, which I believe in this context, is Article 324 of the Indian Constitution. Article 324 of Indian Constitution, if you want to have a look at the bare act, you can go and have a look at it. It talks about two very specific things. It talks about the creation and the constitution of the election commission, that is to consist that it shall always have a chief election commissioner, which means that there cannot be any situation where there is no chief election commissioner and other members as from time to time may be decided by the president. So it is not necessary for the election commission to have election commissioners, but it is mandatory for the election commission to have CEC. But that's not the main point of discussion. It says that the election commission shall have the complete superintendence, direction, and control for the creation of electoral lists, electoral list for the elections to the president and vice president, and for elections to the parliament, which means the two houses, and for the elections of state legislative assemblies, which in some cases might consist of two houses, the Legislative Assembly and the Legislative Council. And it says, and the direction of, sorry, and it says the direction of such election. The usage of the word is very clear. The usage of the words makes it so clear that on various occasions, Supreme Court has upheld the power of the Election Commission to do whatever it may want to do in order to fulfill its function of directing an election. What does directing an election means in a free and fair democracy, in a procedural democracy, in a substantive democracy? What does direction means? Direction means holding the charge, commanding the election in such a way that they provide level playing field, they provide free and fair rules for to allow India to grow into multi-party democracy. Using such powers, Election Commission from time and again has asserted itself in various ways. On some occasions, the Supreme Court has supported such assertions. On various occasions, Supreme Court has not been on the same page as Election Commission. Just to give you a quick example, Election Commission introduced electronic voting machine in few constituencies in Kerala in 1980s because it thought it was the in charge of the election. It was challenged in the Supreme Court, and Supreme Court struck down such action by the Election Commission, saying that the overall direction of Election Commission should be guided by, first and foremost, the constitutional provisions. So it cannot override the provisions of the Constitution just because it is expected to direct an election. So it is bound by the Constitution. After the Constitution, whatever laws that have been laid down by the Parliament, for instance, Representation of the People Act, it is bound by that. And if there is any scope, if there is an avenue left, which probably leaves a lot of ambiguity, void, loophole, then maybe Election Commission can fill in with their rules. And that's why Election Commission realized that probably the laws and the Constitution leave a lot of void in terms of how elections are contested. And there are a lot of anomalies that are observed when the elections are conducted on a regular basis. So initially, Election Commission urged all the political parties in 1960s to voluntarily come up and sign a document which became Model Code of Conduct. Model Code of Conduct is that ideal behavior expected from all stakeholders in observance of an election. If they all abide by that, then no one will have any complaint either on the election process or on the electoral results. Model Code of Conduct is that utopian document that has been produced by the Election Commission, where, as you will soon realize, that if everyone observes it, no one will have any guilty, no one will have any qualms with respect to the electoral procedure that is to be followed in India, or that will be followed anywhere whenever the elections are supposed to be conducted. So let's now look at this document and let's talk about how the issues or concerns are being raised. Model Code of Conduct, or what is known officially as Compendium of Instructions, or colloquially known as Model Code of Conduct, is broadly divided into 8 very distinct set of instructions that are to be observed. Some are very general instructions, like for instance, they also form the part of RPA, but they need reinstatement. So the general part of the instruction includes general instructions like avoiding derogatory language, not using any of the ascriptive identities, the identities that you're born into, like caste, you're born into a caste, you're born into religion, you're born into a region. So avoiding that, not using slangs while or dividing communal speech, all of that is a general instruction, so that there's nothing much specific about this part. But before an election can be conducted, you can see that while campaigning, the political parties and candidates hold a lot of meetings. So, in order for the election commission to be able to observe the meetings and procession, it is expected of all the participants to duly inform the administration a priori and take the permission of the election commission or the returning officer, who happens to be the district magistrate in most of the cases, about a particular meeting, political gathering. It is important because we have seen recently what has happened in Bihar. Two opponents, procession crossing each other, broke out into an altercation, and eventually it led to the death of one of the active political workers of RJD. The accusation has been made on Mr. Anand Singh as of now. So you can see it is very, very important for the local administration to draw the procession so that they do not conflict with each other. To avoid the confrontation, it is expected of all the participants to follow through on these things. Then recently, Election Commission of India has amended the Model Code of Conduct to include manifesto and specifically about welfare policies focusing on freebies, because a trend had emerged in last 2 decades where just before the elections are to be announced, the political party in power or maybe opposition, they announce schemes which can be completely decoupled from welfareism and freebies. So a good welfareism is a policy which does not becomes burden on exchequer, which focuses on empowerment, long-term investment, which focuses on or is concerned about the development of human capabilities like investment in education, health, infrastructure. Whereas on the other hand, if you look at short-term freebies, which are bad welfareism, which can be recognized as populism, where the political parties, just for the short-term electoral gains, end up announcing policies which have no correlation with human development. Distribution of cash has no relation with the development of human. If that was so much good, you could have just gone for universal basic income, but there is a reason why we don't go for it. And so the election commission has now put a lot of expectations on the political parties, that especially with respect to welfareism, that they will have to follow certain rules before they announce. What are those rules? These rules are: number one, you have to show how much expenditure it is going to cost the exchequer, and where are you going to get the revenues. So first you will have to show that how you are going to manage the finances, only then election commission is going to allow you to announce such schemes. The model code of conduct is just not limited to one day before the election. It is applicable on polling day as well, because on polling day it mandates all the political parties to behave, because ruckus created during the voting can have ramifications which can be beyond the control of the local administration to manage. It's just a normal rumor that the EVM is being hacked at a particular polling booth, or maybe a particular polling booth being captured by a single political party, can have wide impact on the credibility or legitimacy of the electoral outcomes. And that's why it expects only the people, card carrying administrators with ID cards, to be present at the polling booths. At the same time, allowed party workers. There are party workers that are allowed from every party, acting as a representative, that they are allowed to be, and just the voters, and no one else should be allowed there. But the most significant part of model code of conduct, and the reason why we are discussing this, is applicable on party in power, both at the center as well as at the state. In this case, it's common, NDA. Bihar is being governed by NDA, India is being governed by NDA. So the model code of conduct understands, or basically it has originated because of this concern of the people in power to misuse their official position, to tilt the balance in their favor. For instance, if I am a minister, let's say if I'm a chief minister, I have all the resources, all the officials of the Bihar government are working under me. All the transport basically is under my command. And so what if during the time of election I use official conveyance, transport, vehicle, cavalcade for my political rallies? Then obviously it's not a level playing field, because the kind of enormous resources I as a chief minister am entitled with cannot be even matched by any kind of political funding. So the model code of conduct pays special attention on party in power, in the sense that it expects the political party in power not to announce any new welfare schemes after the announcement of elections, which means when the model code of conducts kick in, the day the elections are announced, model code of conduct kick in. Not to combine their official visits with the political rallies, not to merge them, also not to use state resources in campaigning. And the article that is written is because of announcement of a welfare scheme just 1 day or 2 day prior to what has 2 day prior to the announcement of the results. So it is not really legal violation of model code of conduct, but it is no less than a moral. That's where the thin line between legality and morality disappear. You can't announce it day after, and that's why you announce it day one. It defeats the purpose of the model code of conduct. And that's where the title of the editorial is very, very clear. It says the malleable code of conduct. A code of conduct that can be molded too easily is what creates problems. Now, if you look at the model code of conduct and ask a question, if election commission has come up with rules, what's the purpose of these rules if election commission cannot penalize people for violation? And as you can clearly see, generally we don't see people being penalized, but it's not the case. On various occasions, election commission has taken strong cognizance of violation of model code of conduct and has taken strong actions in the past. For instance, in 2014 elections, during the elections, Mr. Amit Shah and Akbaruddin Owaisi both were barred from campaigning for 2 days in Uttar Pradesh because of their communal speeches. Similarly, Mr. Yogi Adityanath was banned from campaigning for 2 to 3 days during 2019 Lok Sabha elections. So it's not like election commission has not or does not or cannot take actions. It can take action by virtue of Article 324. It's all about the will to use it. But there are certain legal measures available to penalize. For instance, there are various sections in the Representation of the People's Act, RPA, which overlaps with MCC. So if there is an overlap between RPA and MCC, there is nothing that the election commission should worry about. For instance, the Representation of the People's Act 1951 declares corrupt practices under section 123. Section 123 of RPA 1951 talks about corrupt practices, defines the punishment, where the election commission can initiate an FIR, and then a lot of the people have lost their membership of parliament and legislative assembly by virtue of corrupt practices. So if there are corrupt practices in law, and if that's also included in model code of conduct, there is no problem. But the problem is that a lot of the provisions are not included in law. They do not have legal backing. And so ultimately we are reliant on the will. we are reliant on the inclination of the election commission, because it is completely devoid of any legal backing. So if the election commissioner, chief election commissioner, wants the cognizance to be taken, wants an action to be taken, then they would take it, but nothing compels them to take an action. That's the problem. So for the longest time, the people have been complaining that since the model code of conduct does not have any legal backing, it is, you can say, up to the discretionary power of the chief election commissioner. And now you know that the chief election commissioner is appointed by collegium with the majority of the ruling executive. Collegium consists of the prime minister, home minister, and leader of the opposition. So you can see there's 2:1 majority. So whoever becomes the chief election commissioner is obviously a very trustworthy and reliable person of the ruling dispensation, and that's why they became the CEC. And that's why most of the people who become CEC, they have been tried and tested, and that's when they become. Also, you can see that India is such a vast country, and when the elections, when India or even the states go for general elections, it is humanly impossible to keep a track of each and every campaign, each and every meeting, each and every official visit. It is a mammoth country. So for a state like Bihar with a population of around 14 to 15 crore people, with so many parties participating, so many contestants on every constituency, how do you think it is humanly possible for the election commission to observe each and every violation of MCC? So vast election, it is impossible to cover, can't cover. Also, because there is so much at stake when there are elections, the political parties leave no stone unturned to increase their probability to win, and they become very innovative. So we have seen how social media has been used, which so far was not covered by the model code of conduct. And we have seen how surrogate campaigning, outsourcing the campaigning to people not directly involved with and hence not covered under MCC, have been used. So you can see that there are very, very unique problems that is faced by the elections in our country, and we should be very, very concerned, as it takes away the whole essence and the substance of democracy. So while India continues to have regular elections, while India continues to, be a country where outgoing powers don't really question the outcome of the election, India has not seen military coup, but the problem is that still India is devoid of the end or the substance of the democracy, which is the level playing field, because of these problems. So for a lot of the scholars have argued that why not we amend the Representation of the People's Act to include MCC within the law, to give it a legal backing, which has been opposed by the election commission on the grounds that if something becomes a law, then the judiciary takes over, and then what we see is just the delays and nothing else. So I think this is enough to give you an idea about MCC. You can go and read the whole article on our website, Anantam IAS. This was a very beautiful quote that was used in the editorial. However good a constitution may be, it is sure to turn out bad because those who are called to work it happen to be a bad lot. So I hope that this quote should be memorized by you and should be used by you in essay. Uncontested polls. Center says right to vote different from freedom of voting. Now, this is important mainly from the point of view of prelims examination, but gives an opportunity to understand how through time, with time, Article 19 has evolved to give us so many rights, but specifically dealing with the democratic reforms. Now, if you're wondering how Article 19 and right to vote or right to contest are related, I'll just give you a brief idea. Article 19(1)(a) talks about freedom of speech and expression. Every citizen shall have the freedom of speech and expression. And so, the question has always been that what does this expression consist of? When I ask students about what expression means, understanding of expression is largely limited to creative expression, cinematic expression, right? Performing art expression. But have you ever thought a unique kind of expression is political expression? Your inclination or disinclination towards political ideas, towards ideologies and political participation. So what it turns out to be that when you go on the day of the voting to press the ballot, you are basically exercising your choice, your expression, which is covered under Article 19(1)(a). And that's why Supreme Court read right to cast ballot as a part of your fundamental right. Now, I want to make it very, very clear over here that right to vote is not your fundamental right. Now, what's the difference between right to vote and right to cast ballot? If you're a citizen and if you are above the age of 18, then the place of your usual habitation or residence might have your name in the electoral list, for which you have to work very hard. If your name is there in the electoral list or not is your legal right. So if your name is not there, despite you qualifying all the conditions, you cannot go to the Supreme Court, because that is your legal right. But once your name is there in the electoral list and then you are not allowed to vote on the day of the voting, that's just a violation of your fundamental right, because you have been devoid of an opportunity to express yourself, and no one can do so until very specifically listed down reasonable restrictions under Article 19 clause 2, which means your expression should not threaten anyone India's sovereignty and integrity. Your expression should not be a threat for India's security. It should not be a defaming expression. It should not be immoral or indecent expression. It should not incite people to violence. It should not be contemptuous on the courts. And so you can see right to cast ballot becomes your fundamental right. And if I give you just one more example, then it will become even more clear. When the EVM reforms were introduced, EVM only carried the same number of buttons as there were candidates. So if there were 6 candidates, there would be 6 buttons. Few people went to the Supreme Court and said, if while expressing I am not being given an opportunity to express the silence, don't you think that's a violation of freedom of speech and expression? Because silence is also an expression. Think about it. If I give you a paper to draw, does not mean you're bound to draw something. You can just leave it blank. That's also can be your expression. In fact, whole modern art has emerged out of that skill of not drawing anything coherently. So you can see that's when the Supreme Court ordered the Election Commission to mandatorily include none of the above option nota, so that all those who want to express their silence should not be devoid of the opportunity to express silence. That's a very powerful reform. In fact, the entire reform with respect to whatever efforts towards decriminalization of Indian politics that has been taken so far has come out of this, because I'm not going to discuss that. Right to speech covers information, because in a state controlled society, if the state is not bound to reveal information, we will live in the desert of information, and we will not be able to make a speech, an informed speech. For an informed speech to be made by the citizens, it is extremely important that citizens have right to know, and that's how right to know came and became your fundamental right. Now, if right to know is your fundamental right and right to cast ballot is your fundamental right, what emerges from the combination of these two is that when I go to exercise my fundamental right to cast ballot, I should be having all the relevant information. And that's when Supreme Court compels all the candidates to an election to reveal their financial antecedents, to reveal their educational backgrounds, and compelled the candidates to reveal their criminal antecedents, which means all the cases where either they have been convicted or charge sheeted. That's a very powerful reform, but not the main concern of today's discussion. Now, why this has become and why there is a case going on in the Supreme Court is because there is a section in the Representation of the People's Act which says that if the number of seats at a particular election constituency is equal to the number of candidates, then it is not necessary to hold the elections. Everyone can be declared as winner. So if there is one seat and if there is only one candidate, this one candidate will become the winner. And that's how you will see in every election, that's one seat in Lok Sabha, there is one MP where there was no contestant to an election, and so only one person was declared as a winner. And this has recently happened in this particular case where there was only one contestant and that person was declared winner, uncontested. There is no contest there. And that's how lawyer Prashant Bhushan has gone to the Supreme Court that, sir, is it not violation of my freedom of speech and expression? Because even if there is only one candidate, we should hold elections. Because if you hold the elections, you will say candidate A and then you will say nota. And let's see what people, because by not holding elections, you have devoid the people of expressing their silence. You have compelled people to agree with just one choice. Let the opportunity be given to all the citizens and they should not be devoid of their silence. By doing this, you have compelled everyone to agree with the coincidental choices that there was no contestant to an election and so that person was declared as a winner. So this is a very thought-provoking case and let's see where it goes. In last 1 month, I've been seeing that there are not a lot of news related to polity. So anyways, I hope this. Let's now move on to the next article, which says a wider SIR, special intensive revision, has momentum, but it is still a test case. So their editorial expresses a lot of concerns with respect to the way Election Commission has been conducting the revision of the electoral rolls. Now, what is revision of electoral rolls? Every constituency has a list of eligible voters. What are the eligibility criteria? Age. What are the eligibility criteria? Citizenship. What are the eligibility criteria? Normal residency or normally resident habitation. You just can't get registered as a voter anywhere if you just moved 1 month before. There are rules that you should fulfill that you get the right to vote at a particular constituency. Now, obviously, because of migration, because of rapid explosion of population, because of in-migration of a lot of refugees from the surrounding countries, Election Commission has been under huge pressure to basically sanitize the electoral list, because from time to time there has been an allegation that first and foremost a lot of the new voters, young voters, have turned up 18 and their name has not been included. A lot of the people have migrated out and their names have not been deleted, which gives an opportunity to the local politicians to misuse their electoral list, because your name continues to be there but you're not there, so someone else can go and vote on your behalf. That's not. At the same time, new people have in-migrated and their name has not been included, and so also a lot of the foreign nationals, especially referring to illegal migrants from Bangladesh, have started living in country and becoming the part of Indian society, and through various mechanisms it has been alleged that they have somehow secured their name in the electoral list. And so the election commission started out SIR in Bihar, but now has extended it beyond Bihar to cover many states. And a lot of questions have emerged as a result of this exercise. Now, if you go to the IS Anantam website, and let me open this article for you. Okay, so I don't think I'll have to search because this was like 4 or 5 days ago. Why the special intensive revision looks like a good idea? I mean, just to give you a brief context, uh, whenever the periodic revision of electoral list is not conducted, it divides many rightful people of the right to vote, and it extends right to vote to people who don't deserve it. So obviously, if SIR is conducted, it is going to do largely the benefit of the Indian democracy. It is going to also safeguard the rights of the citizenship, because you have to make sure that it is available only to the citizenship. And obviously, you have to include new voters. So around 21 lakh voters were included in Bihar. But why it is being criticized so much is not the end goal, but the means to achieve those ends. Number one is the requirement of such a heavy documentation. Whenever you keep the benchmark of documentation very high, you make sure that people, especially from vulnerable sections of the society, will be deprived of their right to vote, because documentation is something which is very difficult, first to obtain and then secondly to maintain by people coming from vulnerable section of the society. And so people are under apprehension that some of the rightful voters are under the threat of disenfranchisement, which means that their franchise could be taken away just because they could not procure or secure the relevant documents. Also, the strict timelines that the election commission has given to its officials, strict timelines, makes people wonder that such a gargantuan task, can it be really achieved in 2 months, 3 months, where each and every voter has to be verified, their documents have to be scrutinized, and then immediate decision has to be taken where they would be, or whether they would continue to be in the list, or whether they should be removed. And so people are basically they're alleging that a lot of the inclusion and exclusion error might occur in the process. I hope it is making sense. So you can see that this is basically a case where a rightful process has been challenged for malintent, where the previous partisan behavior of chief election commissioner has led to the credibility issues. So I think this week there has not been much news. So let's now move on to the last news, which is over 70% of India's prisoners still await trial. This statement has been made by the Supreme Court judge. And a very, very similar remark was made by another Supreme Court judge 4 years ago, where at that point of time also the number of people who were under trials lodged in India's various jails, around 70% of them were under trials. Now, this has brought issues with respect to the human rights and various challenges related to the protection of human rights in our country. But before we go into and address this issue, we'll first have to understand what really legally under trial means. Is there any such term like an under trial, or why people are lodged in jail? Because probably they have committed a crime, all sorts of these things. If we are first able to understand that and address that, then probably these kinds of observations will make sense. Now, to give you a context, in last 4 to 5 years, UPSC has indeed started asking questions with respect to like shallow, understanding of or the basics of the criminal law in our country. And from that perspective, this particular news article becomes very important. from the mains point of view, when we cover various issues related to judiciary, we cover the backlog and delays, and large number of under trial people uh, facing trial and waiting for their conviction or acquittal becomes one of the negative consequences of huge judicial delay or the backlog. So let's start this, and let's first understand various stages of criminal trial. Criminal trial usually begins if a first information report or an FIR is lodged for a cognizable criminal offense, an offense for which the state cannot deny cognizance, like rape, murder, theft, burglary, kidnapping, abduction, all of these. Whereas if some certain offenses are non-cognizable, then a non-cognizable report is filed. Once an FIR is filed, you know that under obligation, police has to, or any investigating agency has to investigate that matter, and the investigation begins. On the basis of the preliminary investigation, the police can identify any person, let's say A, as an accused person, and might have substantial grounds to arrest the accused person A. But you know that there is an Article 22 which takes care of this situation, where unless and until A is an enemy alien for the time being, or A has been detained under Preventive Detention Act, it is obligatory on the detaining authority, in this case for instance police, to produce the person in front of the judicial magistrate within 24 hours. Let's say FIR was lodged on day 0, police identified person accused, let's say 72 hours down the line, and arrested that person at the same instance in the same hour. Then between 72 and 96 hours, excluding the travel time, it is mandatory on the police to produce this person in front of the judicial magistrate, in front of the judiciary. Now, the future course of action as to what will happen with this person will be determined by the judicial magistrate. Remember that police has not completed the investigation. In the process of investigation, this person was apprehended and was detained. Now, the judicial magistrate has a lot of options in front of her. One of the options is that judicial magistrate is not convinced at all about the detention or the grounds on which the person has been detained, and hence the judicial magistrate might straight away give bail to the person, giving him or her liberty, or might quash the FIR as well. For instance, if police right now arrest a person on grounds of being homosexual, then the judicial magistrate might just quash all the case, as it is no more a criminal offense in our country. There is a possible case where police might be able to convince the judiciary that this person needs to be with the police for at least few days, because this person's physical access is important for the investigation. We want to take this person on various locations, we want to interrogate this person. So in that case, if the judiciary is convinced, judiciary might give accused A's physical custody to the police. In that case, the person does not goes to the jail, the person goes back with the police to the police station or their offices, or they're lodged in station houses, thanas, and all of that. It is usually given for a very limited period of time, like 7 days, 14 days, and every time police has to convince judicial magistrate to extend the police custody. But there is also a case that police is not able to convince the judiciary the physical handover of the accused A. But at the same time, the accused has not been able to convince the judiciary that he should or she should be free. And in fact, judiciary starts believing that if this person goes out, there are substantial grounds to believe that they might interfere with the investigation. They might want to influence the witnesses, they might want to tamper with the evidences, they might want to use their influence to change the course of investigation. In that case, judiciary or the judges order the judicial custody of the accused, which means they will not remain with police, but they will not be free, they will be lodged in jail. That's the problem. That's where the problem begins. Because number one, this person who has just been an accused, remember, it's not this person is not guilty, the charges have not been filed against that person, investigation is going on, but this person is lodged in jail. Now, obviously, for a free and fair investigation, it is important for this person to remain in jail, but only as long as investigation is incomplete. The day police files a charge sheet, then this person should automatically get bail from our judiciary, because now the trial will go on in the court, evidence have already been collected. So if this person goes out, cannot tamper with the evidence, cannot influence the police action, and so it is immaterial if this person is inside the jail or outside the jail free. But that's not what happens in our country. That's not what happens in our country, because in order to secure bail, there are few conditions that every applicant has to satisfy. What are those conditions? These conditions are very simple. Number one, in order to secure bail, this person first has to come up with a guarantor, who, like a person who will take the personal guarantee, promise the court that if this person abscond after securing bail from the court, then I am here to pay all the penalties as you might wish. So you need a guarantor. Also, every bail has a bail bond, like a draft, some money secured at the hands of the judiciary, because after the judiciary releases the accused, what if the accused flees the country, flees the jurisdiction, and never appears for the trial? That will be a very unjust situation for the police and law enforcement agencies. So there is a hefty sort of a fine that is imposed on the people, like in the form of bond, which will be forfeited if you disappear. So it's like a motivation for you to appear in the trial, otherwise the money will go away from you and will not come to you. These things have to be argued by a trained professional, legal help, a lawyer. And now you can see where the problem begins. After your judicial custody is extending the police investigation, so police, let's say, took 60 days for investigation and you're still in the judicial custody. The day police completes the investigation, ideally the next day, there should be a lawyer that you or your family hires or your relatives hire. They should be ready with the bond amount, and then there should be a guarantor. What if you belong to one of those families, you are an unfortunate person who neither has legal help, who has comes from a very poor background, and there is no one known to that person who is confident enough to act as the guarantor? What will happen to you? You will be lodged in jail. And this is the reality which the Supreme Court judge is talking about, where if there are 1,000 people in the jail, only 30% of the people, if there are 1,000 people in the jail, only 300 people are convicted. The rest 700 people are on various stages of trial. So their life and personal liberty is being deprived without any procedure established by law. And that's the violation of Article 21. That's the violation of human right, because life and liberty as thought of in a constitution written for humans is a human life. And that's where it comes in conflict with the human rights. So you can see that's why in a very, very important case law, Hussain Ara Khatun versus Chief Secretary of Bihar, Supreme Court clearly ordered speedy trial, speedy criminal trial as a part of fundamental right under Article 21, because only a speedy trial can ensure just, fair and reasonable procedure. Because remember, after Maneka Gandhi, any procedure that deprives you of your life or personal liberty has to be just, has to be fair, and has to be reasonable. A delayed trial is basically unjust, unfair to people because they are being deprived of their liberty, not because they have committed a crime. It will be found later on whether they have or they have not, but still they are deprived of their loved liberty. Now, the question is, why do we allow this to happen? And how does this happen in our country? What are the reasons behind such a large number of under trials lodged in the jail? See, number one, we can say is uh, the district judiciary or the judiciary at the local level, which is responsible for bail on a day-to-day basis, is inherently disinclined to give bail because they are worried about the public opinion. Because let's say a rape has happened, and while investigating the particular rape or murder, police identifies two people who were closely linked to the event or the incident. They are taken under custody. Now, the local judiciary lives among local people. So remember, Supreme Court judges live in Delhi. The case could deal with any place in the country, far distantly remote. But the judicial magistrate lives in the same locality where this incident has happened. So the bail, rather than being a rule, becomes an exception. It is very hard to get the bail from the lower courts because of the fear of the backlash from the people. So district judiciary, rather than being moved by the constitutional morality, gets moved by the social or public opinion, which is the last thing that the judiciary should be doing. And that's why largely in criminal matters now we see that most of the bails are generally secured at the high court level, not at the district court level or maybe at the special court level. Also, because there is already so much of pendency in the courts, judicial delays, those judicial delays also get reflected in all sorts of cases. So if there are lakhs of cases that are backlogged, then obviously the impact of that backlog, that clogging, will be reflected even on bail petitions, the petitions which which are with the intent of securing the bail for a person. So it's not like they are away from each other. And why this is problematic is because of the social economic profile of Indians. As we have already seen, that in order to secure bail, you need to be from a socially economic well-off family or a background. But we know the social realities as they exist in India right now. And that gets reflected in the social profile of all the prisoners. Two-thirds, every 2 out of 3 under trial in our country belongs to OBC or SC/ST community. Why? Because these communities and their socio-economic profile is so bad that they lag most of the 3 indicators which are necessary for bail. So because you can see, this is the reason how poverty acts as a check on your liberty. So it is important to resolve this situation, because what if tomorrow any one of you who is watching the lecture is accused of any kind of offense in our country and fails to secure the bail, which is your right? It is a violation of human rights. It is basically, you can say, it creates a mental health epidemic. It also creates a problem where so many under trials are lodged with people who are proven guilty, who are convicted. It is such a gross mistreatment of people to put under trials accused with the people who the court has agreed are criminals. And so we need to resolve this situation. And that is why Justice Amitav Rao Roy committee was set up. So Justice Amitav Roy committee was set up, and it recommended various reforms. Number one reform was that instead of going for the judicial custody, the judiciary should offer alternatives to detention. What do we mean by alternatives to detention? Alternatives to detention means that it is not necessary to push people towards jail. There are two important mechanisms that can get you rid of this phenomenon. Number one is plea bargaining. What is plea bargaining? Plea bargaining is something that is not only going to reduce the burden on the judiciary, but it's also going to drastically reduce the number of people who are under trial. Plea bargaining is a legal mechanism where the judiciary offers an accused person a chance to accept the lower crime to get rid of or be exempted from being tried by a higher crime. It basically incentivizes the accused. It's like an offer given by the judiciary to the accused, and that provision has been made available in our country in Bharatiya Nyaya Sanhita, where if you are apprehended for a particular crime, we know that it is going to cost a lot of human resource, time and energy of police to collect evidence. Then a lot of the time judiciary will have to deploy to eventually arrive at the final conclusion. What if we ask you to accept a lower crime, take the punishment for it, and then you are exempted from being tried for a higher crime? It has been seen in the Western countries that most of the people who follow through this, most of the people who are genuinely involved in the crime, they have a higher tendency. So what will happen? You will not go to jail, you will not be detained, you will immediately start your trial, and you will be basically there will be no trial because you have already accepted you have committed a smaller crime. You will go to jail as a convict, you will finish a short sentence as compared to the larger sentence that you were being tried for. So these are the mechanisms which Amitabh Roy committee recommended, which were basically brought into Indian laws as well. So also Amitabh Roy committee has said that the National Legal Service Authority, NALSA, or free legal aid doesn't seem to be effective at the district level. District level, it is largely it largely concerns with very minor cases, not the major cases of criminal nature, because of the lawyers that impanel themselves for free legal aid are not qualified enough. Maybe they are not enthusiastic or compassionate enough, and for n number of reasons, it is very difficult to get justice, and that is why they recommend that the Supreme Court should incentivize uh, high number of lawyers in the free legal aid so that this number of under trials can be reduced. And they have recommended the segregation of under trials. So every jail should have clear-cut distinction between people who are convicted, which means people who have been proven by the court of law to have committed a crime, from under trial those people on whom the cases are still going on. This should be done. So I hope that this issue is clear.